Hello, my name is Olurotimi Osha. I'm continuing with my discussion on, uh, what goes on in law school, right? So I'm a graduate of George Washington University Law School. I got my Doctor of Law degree from George Washington University Law School. I did additional specializations. I was an exchange student and intellectual property law fellow at Bocconi University in the spring of 2018. I also studied international human rights law, the program at Oxford University in the United Kingdom. So I have several friends interested in going to law school. So I'm doing these videos to help them understand the process of getting into law school. And then when they start their first year, what happens? What will they expect? I did an earlier video talking about the first year courses, right? The first year courses, which are the courses that are tested after graduation from law school. Those are the courses that are tested on the bar exam, depending on what specific state bar you want to take. So that's civil procedure, um, criminal law, criminal procedure, there's contracts, there's torts, there's evidence, there's property, and one more, which one haven't I mentioned? Constitutional law, right? So those are the courses that you take in your first year of law school. One course I didn't mention was legal research and writing. So you're going to do legal research and writing because lawyers, they research cases a lot. They study, so you learn how to analyze cases, right? In legal research and writing, that's where uh, you hone your analytical skills. Now you'd expect that since lawyers use critical thinking analysis a lot, that maybe we'll take a course in logic and analysis. No, law school doesn't teach you anything such thing. You don't necessarily learn it in your undergraduate as well. You're not required to do it. If you take math, if you have a math degree, well, you learn to be very analytical. You can take logic on your own. I decided to learn logic on my own. I got a book and just learned logic on my own. I did linear algebra, but all and those things. So those are things that help your logical, critical thinking skills. You learn analysis. I took courses in philosophy on my own, but you're not required to do that before you get into law school. And when you get into law school, even though you'll be doing a lot of analysis, you're not, it's not one of the courses you take. You don't take a course in analysis or logic or logical reasoning in law school. You don't do that. So America is a society. So our law schools are actually fashioned according to the mindset, right? The philosophy and the principles, underlying principles of America. America is a practical nation, do it yourself society, right? They're very practical. Americans believe, uh, they're not, they don't think about an issue, they just do it, right? They just get into it and they'll solve the problem. They play it by ear, they wing it. That's sort of how law school is. You just get into doing things. So you're analyzing cases, you study cases, and the way they devised American law schools, they believe that your analytical skills and ability will come out. They'll develop from just reading cases and opinions and the analysis of the greatest jurists in American history, right? So that's what we're doing. It's just like if I were to use an analogy, think about like driving a car. The American mindset, the American philosophy would be, rather than get a book, a training manual, a book on reading, learning how to drive, right? By reading a book, Americans would rather you just get into a car and start driving, right? And you learn as you go along. Don't quote me on that. This is not legal advice. Americans want you to take, the laws say that you should take an exam, a written exam. They don't care if you read the book. Take the exam, pass it, and you're going to go to driving school. Somebody's going to watch you drive, right? So don't quote me on that. I've not said that you should get into a car and start driving. You'll go to jail if you do that, right? So this is not legal advice. But anyway, you get the picture. America's a practical, do it yourself, practical, hands-on experience environment. And that's sort of how law school is. You don't take a class on logical reasoning or critical thinking as a lawyer. You just start analyzing cases. You just start reading the opinion of professors. So America, you're introduced to the Socratic method, right, in American law schools. The Socratic method. So you in every class you have, your professors are going to engage in the Socratic method. They're going to basically pick on one person and they're going to ask them probing questions, and you're supposed to answer according to what's called IRAC, right? IRAC, and you learn IRAC in your legal research and writing skill class in your first year, which you take in your first year. The IRAC method, that's issue, rule, analysis, right, and conclusion. That's IRAC, right? Right. So it's an acronym: issue, I is for issue, R is for rule, A is for analysis, and C is the conclusion. And somewhere in there, there are facts, right? The facts of the case. So you learn to brief cases on your own. You're going to learn to brief cases. So again, in law school, what you're going to be doing is you're going to have a lot of readings. Your readings can be, for a semester, a day. You could have as many as 500 pages to read a day, right? 500, and you're reading every day, preparing for each class up to 500 pages. No kidding. Between 80 to 500, that's the range. Well, that's 80 is too low, too conservative. Between 200 to 500 pages. 500 on a heavy day if you have a lot of work. So 500 pages a day, not for the week, right? But the thing is, once you get used to it, you're not going to read everything. You soon learn how to sift what's important, right? What's relevant. You sift the wheat from the chaff, so to speak. So that's what you start learning in your training in law school. You learn there's certain things that are just not important. It's just like so you're reading the cases, the opinion of the justices, right? The outcome, the conclusion, the dicta. The dicta. Those are the unnecessary, discussions on law. They're not necessary because if you've listened to a discussion, right, an oral argument of the U.S. Supreme Court justices, you notice they're very long, and the justices are just asking like the attorneys to tell them things, and sometimes it just seems like they're meandering. So there's certain things that are just dicta, they're not necessary to the case. So you see the opinions are very, very long. Some things are not important. There are lots of facts. So briefing cases helps you to spot the issues, right? What is relevant, and that's what you're going to be doing throughout your life as a lawyer, and you're going to learn to do this later on in life. So people value lawyers when you graduate because of your analytical skills. You can read thousands of pages and you know what is important, right? You know what is important, what is not, right? So in briefing the 50-page opinion of a justice, of a judge, right, you're going to look for the rule. There's a rule in there, right? A rule of law, right? Many times I mix the rule with the holding, right? Rule and holding, it's often together. So the rule is a general rule, principle of law, general legal principle. That's a rule. So every time you go to court, there's a dispute, right? Our courts, Article 3 courts, right? That's what they're called, Article 3 from the Constitution. Remember, the Constitution is the supreme law of the land. And the U.S. Constitution set up the Article 3 courts. States also have their courts as well. You're training to be a lawyer, you'll be appearing in one of these Article 3 courts. That's your job. Those courts are set up for disputes, right? Cases and controversies. There's a controversy, there's a dispute. You're not going to court for an advisory capacity for a hypothetical case. There's a real dispute, right? And so you learn in law school, reading all these cases. Part of what you're learning in your 3 years of law school is what is justiciable, right? What is justiciable? Justiciable means something is ripe for the case. There's a controversy, there's a dispute. It's a case ripe for the court to decide, right? And it's not moot. That means it's not irrelevant. It's not been decided already. there's an actual controversy, and you're coming to court for the judge to make a decision, right? So, in briefing cases, you're going to brief cases according to, and the way you brief cases, this is how you approach the Socratic method when you're called on, right? Cold called in class by the professor, right? So the ruling, again, that's a general application of the law. Then there's a holding, right? Some law schools will merge rule and holding together, right? And that's what I did. Rule and holding is together, right? Because the holding is more specific. The holding is applying the rule, right, to the specific facts of the case to get a conclusion, right? So the judge eventually provides an outcome, a conclusion, a ruling, right? So that's a holding. Then there's an issue, right? There's a question. So you went to court. Remember, Article 3 courts, there's a controversy. Something has to be justiciable, right? There's a problem, there's a controversy, there's a dispute. That's why you've come to court, and they're trying to settle that dispute, right? So they're parties. There's a plaintiff, the complainant, the original movement. They're the ones who brought this dispute to the court, and there's a defendant who's countering, who's saying no. They're disputing. So there are two parties contending, right? Opposite parties, and the judge is the referee, right? The judge is a referee. In law school, in a federal law school like I went to, it was, we learn a lot of federal law. So we were reviewing Supreme Court justices' cases, right? Cases before the Supreme Court. That's the majority of what we're looking at. Sometimes because that's the Supreme Court, they decide on the Constitution, things that affect the Constitution. Yes, you're going to come in contact with other lower courts' decisions and reasoning as well, but we study a lot of Supreme Court's decisions, the opinions. So then the issue, that's the issue. The issue is a question, right? You could consider it as a question. By the way, the ruling, the holding is not a paragraph. It's just something like a sentence. Right? It's got to be sentence. You learn to be concise in legal research and writing. In law school, you have to be concise. You can't just be writing these long screeds. No. So the rule of the holding is just a sentence, right? There's a rule of law, a principle, and then the issue, that's a question. Why are you in court? What's the issue? What's the dispute, right? What's the dispute? For instance, consider the rule, the issue in the case of Trump versus Barbara, 2026, birthright citizenship, right? Does the president's executive order conflict with the U.S. Constitution? That's the issue. I don't know if that's exactly how it is. By the way, I want to read the full case. I read bits of it. So something is a question, right? So eventually they rule yes, right? 5-4. The Supreme Court decided it violates the 14th Amendment of the U.S. Constitution, right? So they overruled the president in that. They struck down the president's executive order. It conflicted with the U.S. Constitution. So it's a question, very specific. You have to be very specific. It can't be vague. It's the question, what you're asking the justices to answer is very specific, and the judges in court are only going to answer what it is that you asked. They're not going to answer. They're not going to rearrange the question for you. They're not going to answer what you should have asked, right? So that's why plaintiffs need, or parties in courts need an attorney, right? An attorney is skilled in drafting a question, an issue, identifying what the issue is. And then there are the facts, right? You have to have facts. That's the background, right? What happened, right? So basically, and then the conclusion. Before the conclusion, again, so that's basically the holding. The holding is the conclusion, but then there's the reasoning, right? The analysis. How and why did the courts reach their conclusion? How did they come to their rule, to their holding? How did they reach their holding? So the holding is sort of the conclusion, right? Um, and all of this, when you're going to do a lot of this, tons of cases, right? Like I said, you can read as many as 500 pages a day, so between 80 to 500 pages, depending on how heavy your workload is, for that day, for the week. It's very, but typically you're reading about 800 to 1,000 pages a week, right? So it's a lot of reading in law school. But the thing is, you soon master the ability to know what is relevant. You learn to sift the wheat from the chaff. You know how to just go straight to it. What's important, what's not important. It takes time, right? It's like riding a bike. So and so that's you do all of that case analysis, the briefing, the IRAC. That's what you're going to be applying in the Socratic method when your professor calls on you, when he cold calls you impromptu, and he's asking you probing questions. By the way, if you want to know what the Socratic method is it's from Socrates. Since considering we love the classics, today a classic was released, right? Written by Homer, right? Homer, the Greek poet, um, the blind poet. Homer wrote the Odyssey, right? The Iliad and the Odyssey. The Odyssey is being released in theaters today. Today is July the 17th, 2026. Homer lived before, Homer's 8th century BC. BC means before Christ, right? So Homer lived 8th century BC. Socrates, roughly 5th century, right? I think roughly but maybe 5th century BC. But Socrates was a teacher of Plato, right? So Socratic method. If you read the Republic, get a copy of the Republic and you can read it. The Republic. It's written by Plato, but he's chronicling his discussions, the discussions of Socrates, right? So it's written in a Socratic method, the beginning. So the Socratic method is Socrates was a Greek philosopher whose habit was to question his students, right? He'd ask them questions, probing questions, to elicit from them answers, to get them to say certain things. So that's a Socratic method. And that's what we use in law school. So Socrates died an infamous, gruesome death, right? So he was charged by the Athenian government, Athenian aristocracy, with corrupting the youth, right? He was corrupting the youth, the morals of the youth of Athens, right? So he was found guilty, and the sentence was for him to die by hemlock, right? Hemlock was poison, right? To die by poison. So he met a gruesome death, but he's been written into greatness because everybody knows Socrates through his great students, including Plato, and law schools still use the Socratic method, his method, till today. So he taught his students to question authority, right? To question authority, to challenge authority. They accused him of not wanting to honor the Greek gods, right? He questioned or introducing new gods. But his methods, basically, he taught his students to question authority, right? Or to question traditions, right? And so lawyers are masters of doing that, right? So they learn how to question everything because they're honing their reasoning skills, and it's through this studying of the brilliant minds and opinions of former jurists, right? Again, using stare decisis. Stare decisis, that means to stand by things decided, right? To stand by things decided, or to stand by prior decisions, standing by things decided. That's stare decisis, and that's based on the doctrine of precedent, and that's why we continue to study prior cases, right? Prior cases that have similar applications. We study them because stare decisis, it allows for stability in our laws, predictability, right, and fairness. So a skilled lawyer, before he gets to court, he goes to look for prior cases that have a similar background, similar facts to what he's experiencing. So there's nothing new under the sun, right? That's basically how the legal profession is. It's very traditional. My name's Olurotimi Osha. I hope this has been helpful. I'll do more videos on the law school experience. I'll keep you posted. Thank you.